Namaste. A hearty welcome to all the viewers for today's session. I am Abhishek, manager from Insolvency and Bankruptcy Board of India. I have here with me Mr. Sushanta Das, DGM IBBI, and we are here today to present on the topic individual insolvency resolution process and bankruptcy process to personal guarantors to corporate debtor. I'll briefly run through the introduction, and let's see who a personal guarantor is first. The code defines a personal guarantor to be an individual who is the surety in a contract of guarantee to the corporate debtor. The subordinate legislation under the rules also defines the personal guarantors to be a debtor whose guarantee has been invoked by the creditor and it remains unpaid either in part or in full. So, and the circumstances in which a guarantee can be invoked are dependent on the terms of guarantee contract, and these are governed in accordance with the sections 126 to 147 of the Indian Contract Act. And the point to be noted here is even if the guarantee is partly unpaid, then action is possible under the code. So, who is the adjudicating authority for the individual insolvency processes? The code under section 60 and 179 categorizes individuals into three parts. One is the personal guarantors to the corporate debtor, what we call as PG2CD. The second category is firms, and the third one being other individuals. So, in respect of these individuals, the general adjudicating authority is defined to be the DRTs. But for personal guarantors, where a corporate CARP or liquidation process has already been initiated and is pending, then the adjudicating authority would be NCLT or NCLAT as the case may be. And for those personal guarantors to corporate debtor where CARP has not been initiated, then for those also the adjudicating appropriate authority is DRT and DRET. Now, I'll hand over the session to Mr. Das, and he'll be running us through the insolvency resolution process for personal guarantors. So, please.
Once again, welcome all of you. So, we'll start with the insolvency resolution process. As my colleague Abhishek rightly pointed out and defined who is the personal guarantor. So, once the guarantee has been invoked and it is not paid, whether it is a partially paid or it is fully not paid, then the creditor can initiate the application, the debtor also can initiate the application. So here the point is both the debtor and the creditor can initiate the application. So there is no discrimination who can initiate the application. So there is rules are also defined. So when the rules are defined, the application formats are defined, in which format the creditor will file, in which format the debtor will file. The only thing is here, once the creditor thinks of filing an application for the insolvency resolution of the personal guarantor under section 95, he needs to send one notice. So after invoking of the guarantee also, he needs to send a notice and he has to give 14 days time to the personal guarantor. So if the personal guarantor pays within 14 days, then there is nothing, the application will not be filed because the debt has been settled. The only thing, if the debt has not been settled, that means the personal guarantor has not repaid, that means at that case the application can be filed by the creditor under section 95 of the code. Then what will happen if the application has been filed? The question arises, what will happen? So once the application has been filed, the term interim moratorium commences. So what is about interim moratorium? What happens is, and why this interim moratorium? Interim moratoriums gives a caution to the personal guarantor. That means once the personal guarantor files the application or the creditor files the application, he gets some caution. That means once the application has been filed, no other creditor can initiate any type of legal proceedings with respect to the debt. Or what will happen if the existing proceedings is going on? Of course, if the existing proceedings is going on, then also those will be deemed as stayed. So that means he will be completely free. There will be a relaxed time so that he can think of how to repay that amount. So this is about the interim moratorium. Then what will happen if the RP is appointed by time, or what is the timeline anything prescribed? Yes, the code prescribes within 10 days, within 14 days, the RP will be appointed by the adjudicating authority. So how the RP will be appointed? So when the applications are filed by the applicants, they are suggesting the names of an insolvency professionals who can be appointed as the resolution professional in the process. But is it mandatory? No. The applicants are, of course, it is not mandatory. They need to suggest the names. So if the names is not suggested, then what will happen? At that time, IBBI, the board, gives the panel every 6 months to the adjudicating authority. So the adjudicating authority takes a name from the panel and appoints him as the resolution professional for the process. So why the resolution professional is appointed? The question comes to mind. So what he will do, he will be getting 10 days time. So within 10 days time, he will submit a report. So what the report will say about? The report will say about whether the application is proper, whether the application is a fraudulent means application or anything. And he will also suggest preliminarily whether the application is fit for admission or it is to be rejected. So the role of the insolvency professional who is acting as the resolution professional in the process, he is having a wider role because he is, of course, initially scrutinizing the application. So whether there is a question comes in mind, the resolution insolvency professional who has been appointed, can he be replaced? Yes, he can also be replaced by the anyone, by the creditor or the debtor. If anybody wants, he can, of course, file an application before the adjudicating authority for replacement of the resolution professional. So thereafter he submits a report, and based on the report under section 100, the adjudicating authority either approves or rejects the application. So now the question happened, I gave two instances, either it will be approved or rejected. Then what will happen if it is approved? What will happen? It is rejected. So if it is rejected means the application gets the process gets closed. That means the process ends there, and by that time what will happen? An application for the bankruptcy process can be filed. So the bankruptcy process will be again taken care by Abhishek later on. So this is a stage where the bankruptcy process can be filed. So then second instance is the admission. So if the application is admitted, what will happen? Again, the interim moratorium which was proposed when the application is filed, that will be terminated and the actual moratorium will start. So what is the difference between the interim moratorium and moratorium? So the interim moratorium, I have told two things. One, the existing proceedings are deemed to be stayed and the new proceedings cannot be initiated. Then what will happen in the moratorium? Apart from those two clauses, again the personal guarantor is given the option as he should not alienate his assets. So this is an additional duty or additional function for the personal guarantor, that he cannot sell off the assets when the moratorium actually starts. So this is about the moratorium clause. Now application has been admitted. So the question, how the people will come to know about the insolvency resolution process of a personal guarantor has been initiated. So there will be the, obviously then a notice should be given. So the notice will be given how? The notice will be given through the newspapers, local newspapers of the residential area of that personal guarantor, so that the other creditors will come about and they will come to know about this process has been started. So what is the meaning of this notice? So by this meaning of this notice, those creditors, they need to file their claim. So when it is filed the claim, they will file the claim before the resolution professional who has been appointed. So now once the claims are filed, what will happen? When the claims are filed, the resolution professional will verify their claims. So he will collect and he will prepare the list of the creditors. So what is the role of the personal guarantors now? Where is he now? So he is also has to do something for this process. The main thing rather, so he has to prepare the repayment plan. So what is about the repayment plan? So repayment plans is nothing. Repayment plan is just a proposal for the creditors to restructure their debts and affairs. So he will prepare the repayment plans. Who is preparing? Personal guarantor is preparing. Whether the RP is helping? Yes, RP can help in preparing the repayment plan for the personal guarantor. But it is of course depends on the personal guarantor only whether he needs the help. So the provision is such, the personal guarantor will prepare the repayment plan in consultation with the personal guarantor. So once he is ready with the repayment plan, he submits the repayment plan to the resolution professional. Mr. Resolution Professional, this is my repayment plan. You please submit it before the creditors or the adjudicating authority as you like. So once the repayment plan has been issued by the resolution professional, he will prepare a report. So in that report, he will mention everything, whether the report is prepared in accordance with the law which are existing as of now, whether the repayment plan proposed by the personal guarantor, it is likely to be implemented successfully. So he will mention those things and he will submit a report to the adjudicating authority. After that, what will happen? As I was telling, the claims have been filed. So one list has been filed. So the list of the creditors have been filed. So he will convey a meeting of the creditors. So during the meeting, he will discuss that all the creditors, friends, I have received this repayment plan from the personal guarantors. So this is for your review and consideration. So the creditors will go through that repayment plan and they will discuss and they will take a call whether this repayment plan to be approved or rejected. So once they think that it's to be approved, means at least 75% of the creditors need to their thumb up. That means they should approve. If 75% of the creditors approve the repayment plan, that means it will be treated that the creditors have approved the repayment plan. So if they will reject, means if 75% has not been reached, that means less than 75% creditors have said that yes, it can be approved, then that will be rejected. If the creditor also think no, this is not as per the law or this some modifications are required, they can suggest for the modification. So if the creditors are suggesting for the modifications, then what will happen? So it will be again considered by the personal guarantor. So if the personal guarantor agrees to the modification suggested, he will submit a modified repayment plan. So once the modified repayment plan submitted, again the creditors, they will consider that, and if they approve or if they reject finally, either of the two, the resolution professional will prepare a report and he will submit that report along with the repayment plan to the adjudicating authority for its approval of rejection or approval of admission. So once the repayment plan reaches the adjudicating authorities again will take a call whether this is to be approved or this is to be rejected, or if the adjudicating authority also later on thinks that it can be modified further, so he can again ask the resolution professional, it needs to be modified. So you discuss with the personal guarantor, you discuss with the creditors and get it modified. So this is a modification clause is also there. So if they think finally, yes, the adjudicating authority, if it is accepted, so he can accept the repayment plan. So once he is accept, means the repayment plan proposed by the personal guarantor, approved by the creditors, finally got approved by the adjudicating authority. But the question arises now, what will happen if the repayment plan is rejected? Yes, so there is a clause now, if the repayment plan will be rejected, in that scenario, the creditors or the debtors, they will be again, they can initiate the bankruptcy process. So initially I told one thing, when can the bankruptcy process can be initiated? That is when the application gets rejected, that application is not getting admitted. In case now, when the repayment plan has been rejected, so this is in a second case, second instances where the bankruptcy process can be initiated. So now we'll go to the application has been admitted. The repayment plan has been approved by the adjudicating authority. So when the repayment plan gets approved by the adjudicating authority, now the duty is casted on the resolution professional to implement that repayment plan. So whatever the terms and conditions given in the repayment plan, it needs to be implemented by the resolution professional. That means he will oversee how it will be implemented. So the repayment plan goes on implemented, and after the proper implementation as per the terms and condition of the repayment plan, the it is finally approved that all the repayment plan has been implemented successfully, the resolution professional again will prepare a report and he will submit it before the adjudicating authority stating that the repayment plan has been successfully implemented. So if that report has reaches to the adjudicating authority by an order, he will discharge the personal guarantor from the debt. So this will end in the resolution process. So what will happen if during the process, during the insolvency resolution process, when the implementation is going on, the debtor again fail to implement the repayment plan. So if he is failing to the implementing the repayment plan, again the resolution professional is empowered to file a report before the adjudicating authority stating the fact that the repayment plan has been not implemented properly, it has been ended prematurely. So what will happen? Again, there will be a third situation where the bankruptcy application can be filed because the repayment plan has not been implemented. So now we are coming to the conclusion of the process. So in three scenarios, when the application is not admitted, that means rejected, repayment plan is rejected, or repayment plan is not implemented properly. So in these three circumstances, the bankruptcy application can be filed. Now I request my fellow colleague, Mr. Abhishek Mittapally, to take through the bankruptcy process. Over to you.
Thank you, sir. Thank you for beautifully summarizing the individual insolvency process. Now, let me take the audience through the bankruptcy process. First of all, we need to understand who a bankrupt is. The code defines bankrupt to be a person who has been adjudged as a bankrupt by a bankruptcy order. And if in case of a firm, if a bankruptcy order is being made, then each of the partners of the firm will be declared a bankrupt. And in case of an undischarged insolvent, he is also treated as a bankrupt. And the next question arises is who is a bankruptcy trustee? Bankruptcy trustee is a person, in fact, an insolvency professional appointed so by the adjudicating authority to deal with the matters pertaining to the estate of the bankrupt. And an undischarged bankrupt is a person who has not received any discharge order as such. So what is the precondition for a bankruptcy order to be made, application to be made? An insolvency process is a precondition, and on the failure of a successful implementation of insolvency process, only can an application under bankruptcy process be made. And when can one make an application? An application for initiation against the debtor can be made. If the application is rejected, then an application for bankruptcy be made. And if the repayment plan is rejected by the adjudicating authority, that is another instance where you can file a bankruptcy or application. And a repayment plan which is duly approved, but it failed to be implemented, and that is also a scenario where we can initiate a bankruptcy application. So the next question follows is like, who can actually apply for the bankruptcy application? It could be applied either by the debtor or by the creditor. The code empowers both the parties to make relevant applications. And once an application is made, the adjudicating authority has 3 months to pass the relevant orders. And there's also a provision for withdrawal given in the code, where only with the due approval of the adjudicating authority, the bankruptcy order can be withdrawn. Once the application has been admitted, as sir was telling in the individual insolvency process also, an interim moratorium comes into effect, and all the pending or forthcoming litigations will be kept on hold. And after interim moratorium is declared, the adjudicating authority also appoints a bankruptcy trustee where it is proposed by the applicants. And in case no proposal has been received by the adjudicating authority for any bankruptcy trustee, then the adjudicating authority appoints an IP from the panel of IPs prepared by the IBBI in this regard. And within 14 days from the order of the adjudicating authority, a debtor will be considered, a bankruptcy trustee will be appointed, and adjudicating authority will provide copy of the application and the bankruptcy order to the bankruptcy trustee within 7 days of the order. Once such an order is made, it remains in effect till the bankruptcy is not discharged, and during such time, the estate of the debtor vests in the bankruptcy trustee. Once after this application, the next step is that a public notice will be issued. This will be issued by the adjudicating authority itself. and it will be issued to all the creditors mentioned in the application, and the public notice so issued will invite the creditors to file the claims with the bankruptcy trustee. And the bankruptcy trustee is also duty bound to maintain a list of creditors and also update it. These list of creditors will have all the information about the application and the statement of affairs of the bankrupt. And once the list of creditors is duly prepared by the bankruptcy trustee, then he will call for the meeting of the committee of the creditors within 21 days from the bankruptcy commencement date, and such a notice will be sent to all the creditors available in the list. What happens? What are the disqualifications of a bankrupt provided under the code? A bankrupt, whoever, after passing an application, he cannot be appointed as a public servant, and even if he is elected to a public office, he'll have to vacate the office, and he cannot be elected or be a sitting or voting member of any local authority as well. The code also provides for certain duties of the bankrupt, and also casts some functions on the bankruptcy trustee. We'll briefly discuss about them as well. A bankruptcy trustee is entrusted to investigate the affairs of the bankrupt. He will also realize the estate and distribute whatever the sum he'll receive from the estate of the bankrupt. So far as the duties of the bankrupts are concerned, the primary duty is to cooperate and coordinate with the bankruptcy trustee and provide all the relevant information, and to attend the meetings or whatever the information as the bankruptcy trustee may call for. And also the bankrupt is also required to provide any significant events that may have occurred after the bankruptcy commencement date to the bankruptcy trustee. The general powers of the bankruptcy trustee include that he is empowered to sell any part of the estate, and he can give receipts of any money received by him. He can also deal with the properties whatever are vested in the bankruptcy estate. There's a chance the code also describes the vulnerable transactions that may actually happen in the process. The code identifies 3 such transactions: undervalue transactions, preference transactions, and extraordinary credit transactions. And all these transactions which are occurring 2 years prior to the bankruptcy commencement date will be investigated by the bankruptcy trustee, and necessary applications will be filed before the adjudicating authority to bring to the logical conclusion. The code also provides for a priority under waterfall mechanism for all the debts that are a part of the bankruptcy estate. The first and foremost priority is given to the cost of the bankruptcy process, and all the costs involved in this process will have to be paid off in full. Followed by these are the workmen and the secured creditors claims. Workmen dues for the period of 24 months prior to bankruptcy commencement date, and all the debts to secured creditors rank second, followed by the wages and unpaid dues to the employees for a period of 12 months. Once these costs are covered, then it is followed by the government dues, either central government or state government, for 2 years preceding to the bankruptcy commencement date. And if these dues are all paid, then follows the other debts. So here now we have to also know, once this process has already till here it's done, then the next process is the discharge of bankrupt. A bankrupt will be discharged by adjudicating authority on an application filed before it by the bankruptcy trustee. Once this application for discharge has been filed, earlier of 2 dates, we have to see whether 1 year from the bankruptcy commencement date has expired, or whether 7 days from the approval of the committee of creditors. Whichever of earlier of these 2 dates, the discharge order will be done. What are the effects of the discharge order? Once a discharge order is passed by the adjudicating authority, then the bankrupt is released from all the bankruptcy debts, and but however it does not affect the functions of the bankruptcy trustee. Following items remain unaffected. One is the right of the secured creditor to enforce his security. The second being bankrupt is also not released in respect of debts incurred by means of any fraud. Bankrupt is also not released from any excluded debt. These are the 3 things which remain unaffected even once a discharge order is passed. So this briefly sums up the bankruptcy process where individual insolvency process fails and bankruptcy process commences. So before we conclude, I have a small question for the benefit of the viewers. Can you envisage a scenario where in the individual insolvency process, before it gets logically concluded, the individual dies? So what happens in that scenario?
Yeah, very good question, Abhishek. During the bankruptcy process has been initiated, and during that time, the bankrupt or the debt or in this case, the personal guarantor dies. So what will happen? So there is a provision in the code. So the code says if the bankrupt dies in between, the legal heirs of the bankrupt they can the court has envisaged that the process will continue as it is, as if the bankrupt is alive. So what will happen? The bankruptcy trustee who has been envisaged with the duty to realization of the estate and distribute among the creditors, he will continue the process, and after that, of course the bankrupt is not there, so there will be no question of discharge at that time, but the process will be completed after the due distribution. And if there is fund anything is excess has been received, so at that time what will happen? So that will be again passed over to the legal heirs. But the same thing now, the question is, as you have rightly pointed out, the insolvency resolution process. So what will happen if during the insolvency resolution process, the personal guarantor is died? So as of now, the code has so far silent about that. However, the committee which has envisaged the code, that is the BLRC, it was discussed that if it is died, the legal heirs, if they want to continue, so they can continue the process of the repayment plan, they can fully implement, so that they can save the assets of the personal guarantor. But as of now, I think the jurisprudence only will develop, and that will say what will happen during the resolution process. However, during the bankruptcy process, it is well defined. Thank you.
Thank you, sir. Thank you for clarifying to our audience here and for bringing to their information the entire individual insolvency and personal guarantors provisions under the code. Thank you, audience. Thank you for the session.
Thank you. Thank you all.